let me know, huh?
Yeah. Okay. So good evening, friends. And when they say that a man can have 2 innings, and especially when you have a Asia Cup, here is a man who is having a 3rd innings. So that's a very rare occasion. An advocate, then senior advocate, a judge, and then back as a senior advocate. So since he's already a senior advocate, so this will be a 3rd innings. So it's a rare case where a man gets a 3rd innings to play. But the important facet is that as a 1st innings, he played good. 2nd innings was better. And I think the 3rd innings will be the best. So before we start with the session of substantial question of law and second appeal versus jurisdictional error in civil revision, as we understand, there are nuances, but for a young lawyer or a young professional, it's a more niche area for a professional to understand. So we thought, why not have a man of the moment who can make us things understand the subtle nuances. And the interesting facet with Justice Amit Rawal, a former judge from Punjab and Haryana High Court, then Kerala High Court, and again senior advocate. So everywhere he plays 3 innings, 2 as a judge, 1 as an advocate. Without doing much introduction on this aspect, I will ask Justice Amit Rawal, a former judge of Kerala as well as Punjab and Haryana High Court, to give the insights of a very interesting facet of law. Over to you, sir.
Very good evening to all of you. Thank you very much. Vikas, 3rd innings is people get a chance to play in a test match. So it's a test match series going on, and I am playing the 3rd innings. So I'm getting a chance.
Within the same match, I'm saying.
Yeah. It's not a one day or the Asia Cup, the T20 or the one we are now going to. That's why probably you preponed the time from 7 to 8 instead of 6 to 7 instead of 7 to 8.
Yes.
So good evening, everyone who is watching this discussion on a question of law. See, Punjab doesn't have the applicability of Section 100 of the Code of Civil Procedure. There was initially a provision of, we called it Punjab Courts Act. And all the regular second appeals were, and now also during the interim, there was some change owing to judgment in Kalwandkar versus State of Punjab. For some time, we have been filing the regular second appeals under Section 100, but all the regular second appeal in Punjab, I'm not talking about other states. Of course, in other states, it is being filed under Section 100 of the Code of Civil Procedure. But in Punjab, it is filed under the Section 4 of the Punjab Courts Act. We have a local act. And if the RSA is filed under section, and it is being, authoritatively held by the Supreme Court, in one of the judgments, yes, the RSA is filed in the Punjab will be governed by the Punjab Courts Act, and it will file under Section 4. So there is no need of framing of a substantial question of law as required under Section 100 of the Code of Civil Procedure. But as far as other states are concerned, of course, it has to be filed under Section 100 of the Code of Civil Procedure on a substantial question of law. Now, there have been many discussions and debates on this, where and when to frame a question of law. Now, there are few stages in a regular second appeal. One stage is when the matter comes in a limine and you dismiss it. Then you need not frame the substantial question of law, or when, of course, you decide in a limine and allow it, then you have to frame a substantial question of law and then hear the other side on all the substantial question of laws. Now, the substantial question law is also a very good art, how to frame it and how to ponder upon it. See, when the suit is originally filed, the onus is on a party to prove the onus, to prove the burden is on a party who is alleging a particular fact to discharge, and then it keeps on shifting, and then again shifting. That is called evidence in first call, and then second, and then rebuttal evidence. Primary evidence is a question which is to be not discussed in this discussion. So once the suit is decided on the facts and the key contents of the both oral and documentary evidence, then a person who is aggrieved of has a right to file a first appeal before the competent authority. Now, in some courts, the first appeal would lie in case you have a pecuniary jurisdiction. Like in Delhi, the suits are originally filed in Delhi High Court, and then the appeal is maintainable for a division bench of the court. And Delhi High Court, who tries the suit, is a single judge who decides it. Whereas in a courts which have a unlimited jurisdiction, it will be the district judge having the jurisdiction to decide the matter which has been taken before him under Order 43. Now, Order 41, the Order of Appeal is preferable under 43, and then for Order 41 also applies. Now, see, the first court of appeal, like in a court which is having a pecuniary jurisdiction, has to decide on being a last court of fact and law. That means there is a scope of reappreciation and rereading of the oral and documentary evidence, and as well as also the appreciation of the laws. That court is the last called a last court of fact and law. Now, where the courts are having a unlimited jurisdiction, of course, the RSA, the regular second appeal, would come up before the High Court. And in a having a limited pecuniary jurisdiction, it will like go to the division bench of the particular High Court. Now, question comes, and there has been many judgments on this point, that whether the regular in a High Court or a court having a jurisdiction to try and hear the regular second appeal would have the power to reappreciate the evidence, both oral and documentary, and whether it is a substantial question of law or not. There have been few judgments which says yes, the misreading of the evidence, misdirection of the evidence is also a substantial question of law. Wrong appreciation of the evidence is also a question of law. Vis-a-vis, I will be touching for everybody's knowledge and convenience the jurisdictional error later on. First, I will be focusing on the substantial question. So, a person who files a regular second appeal, where we file under Section 100, of course, the drafter or the person who drafts the regular second appeal is required to frame a question of law which, according to his comprehension, arises. But it is not binding upon a High Court to go and follow the same very question of law after hearing the arguments, while admitting the appeal or while hearing the appeal in a limine and after issuing the notice to other side, is required to frame a question of law. Now, the other party, as per the provisions on, in case the notice is issued and another party is called upon, then the other party has a remedy to raise objection under Section 100 and Section 104. Just a second, I will go through that. Ah, 100 and yes, under Section 105, while hearing the appeal, already when the some substantial question of have been framed, and after hearing the matter at length and examining the evidence, whether there is a on the topic of whether there is a misappreciation or misdirection, or whether a particular evidence in piecemeal has been read into not the part of the cross examination, because evidence as a whole has to be read not in piecemeal. This is already a settled proposition of law. Finds that over and above the question of law already formulated, requires another substantial question law. The court has the power to frame the substantial question of law under subsection 5 of Section 100 of the Code of Civil Procedure. It says, the appeal shall be heard on the question so formulated, and the respondent shall, at hearing of the appeal, be allowed to argue the cases which does not involve the question of law. But in meaning thereby that he would have a right to say that no, it doesn't involve. But then there's a proviso. Proviso says, provided that nothing in this subsection shall deem to take away or abridge the power of the court to hear for reasons to be recorded and the appeal on other substantial question of law not formulated by it, if it is satisfied the case involves such question. Now, Once the High Court decides this point, it can always say that this substantial question of law is involved, and therefore it would not be appropriate and proper for the High Court to decide on that point. It has the power to remand. Now, remand is also a part of a regular second appeal and is connected to the interrelated to the substantial question of law. The High Court can keep the regular second appeal pending on a particular substantial question of law, frame it, and send it back to. It has two options. Can send it back to the appellate authority to decide that decide on a particular point on an issue which has escaped the notice of the appellate court or has been not properly appreciated under Order 41 Rule 25. And similarly, if the appellate court is seized of the matter and finds the similar fallacy on the part of the civil court, it can also remand on the same terms under Order 41 Rule 23 and seek a report and then give a finding. Now, in a case where the High Court has remanded back, can always seek a report either from the trial court or from the appellate court. And then, after seeking the report on the substantial question of law, which it found to be required to be framed not at the initial stage of admission of the appeal, but at a later stage at the final hearing of the appeal, then the RSA can be again decided on that. Then, of course, one of the party which is aggrieved of can always challenge it in a competent court of law, like Article 136, it can go to the Supreme Court. Now, there is a very interesting proposition, probably nobody has touched it. This proviso can also be interconnected with the purveyance of Order 41, Rule 22 of the Code of Civil Procedure. Now, what is Order 41, Rule 22? If somebody is having a CPC, they can always have a ask to that. It is an option to the party who is a respondent in a regular second appeal to challenge some findings rendered by the courts below, particularly the lower appellate court, on a particular issue, though decree is not against him, or some findings which are really affecting him by filing a cross appeal. And the cross appeal and cross objections can be filed within a period of 30 days from the date of hearing. And the expression date of hearing has been read extensively and interpreted by many judgments of the various high courts, including our high court, the effective regular hearing, not the motion. So it is not necessarily the person, suppose on a first date of hearing, a regular second is admitted on by framing the question of law, and the hearing comes after 10 years. And when the party gets a notice and the hearing is listed, it has still 30 days to file the cross objections. That has been discussed in many judgments, and that has been thrashed out. You need not delve on that point. So now, while hearing the cross objection, this proviso can also be taken aid of by the High Court while hearing the both cross objections and the regular second appeal together, whether while hearing the cross examination it finds it imperative or otherwise that a substantial question of law which has not been framed at the time of admission of the appeal filed by the other party is required to be framed and requires a framing and determination. So that aspect probably is also, according to me, is also interconnected. It can't be delinked because some people would not have the knowledge of the purveyance of, or would not have gone through the purveyance of Order 41, Rule 22 of the Code of Civil Procedure. Now, the regular second appeal is also interconnected on a substantial question of law with Order 41, Rule 33 of the Code of Civil Procedure. It is very interesting and intriguing to read Order 41, Rule 33 of the Code of Civil Procedure, which I will read to all of you. It is a very knowledgeable reading of. You will be having a good knowledge of acquire a good knowledge on reading of these provisions, because it is a provision which is sometimes not being used in common parlance in the proceedings before the appellate authority, that is the first appellate court, and as well as before the regular second appeal. Now I will read it for you. And if we read this also, it will also be interconnected and interlinked with the substantial question of law. Now, if anybody is having a CPC on the table, can always take assistance or can also on Google search it and find out. It says power of the Court of Appeal. Appellate court shall have a power to pass any decree and make any order which ought to have been passed or made or to pass or make such further or other decree or order as the case may require, and this power may be exercised by the court. Now, the next line is very important. It is a non-obstante clause, notwithstanding that the appeal is as to part only of the decree and may be exercised in favor of all or any of the respondents or parties, although such respondents or parties may not have filed the appeal, meaning thereby other party even may not have taken a remedy of cross objection, which I just referred to as provided under Order 41, rule as provided under Order 41, Rule 22 of the Code of Civil Procedure, or objections, and may, where there have been decrees in cross suits or where two or more decrees are passed in one suit. That is a different exceptional circumstances where two suits are filed and clubbed together and decided together. This will not be relevant for this purpose. Meaning thereby, I can give you a very hypothetical question, hypothetical proposition, which can make you understand, though it is not related to regular second appeal. For example, or it is related to regular second appeal. Suppose other party has not filed a cross objection and court finds by exercising the power of proviso in those courts which have an applicability of section 100 I'm talking about, because our high court has no applicability. So therefore the power of the high court while trying and deciding the regular second appeals is more wider and vast than as truncated in section 100 vis-a-vis the other states where section RS is filed under section 100. Court realizes that other party had also pressed a rebuttal issue, had also asked for an issue which was not rebutted by the plaintiff, and the finding should have been granted in favor of the defendant in a suit. Then under these provisions of Rule 33, Order 41, while exercising the powers of proviso under Section 101(5), where it is applicable, and while exercising power under Section 4 under the Punjab Code Acts, court can modify the decree, even can grant a relief to the other party who has not filed an objection. For example, against the land acquisition, a party seeks a reference for enhancement of the amount of compensation awarded by the collector. In the old act and the new act, the procedure is different, little bit, but it is almost alike, and seeks a reference to the land acquisition collector to a competent court for adjudication. Now, few of the and a compensation is granted or amount is increased. Now, the state comes in an appeal before the High Court, challenging the enhancement. Now, in the meantime, few of the cases where the similar situated landowners had availed the remedy of also an appeal along with the appeal of the state to the High Court and placed on record certain material by way of additional evidence, or even on the basis of the material which is already part and parcel of the record of the courts below, and makes out a case for further enhancement, and which results into dismissal of the appeal by the state, and that is brought to the notice of the other bench or when the bench is hearing the other batch after some time, then the court has the power, in the absence of any cross objections or cross appeal filed by the landowners in an appeal filed by the state, to get a relief similar or akin to what the relief has been granted to the claimants in the other connected in other matters which have no connection, either they were not clubbed or connected. So that is the power of the court under Order 41, Rule 33, which has also a. This was an example which I given, but it is also connected with the regular second appeal. Excuse me. So I will give you certain reference of certain citations which will help you to note down regarding the judgments on the substantial question of law. One is 2005, volume 12, SCC page 131, Balmukand S. Baruka versus Shankaral G. Khandelwal. Now, it was a very interesting case where the question of framing the question of necessity of framing the question of law was pondered and debated upon at to what stage. The courts in paragraph 10 and 8, the Supreme Court said, necessity to formulate the question of law in respect of a particular point, like a misreading of the evidence, the view taken by the court is perverse, is to be framed not at the end of the judgment, but in the initial stage of the judgment, and the court has to discuss and give the findings on that point only. Now, it's very interesting to note the question of law have to be also read with there is a provision of Order 41 which is called a points of determination, which is vested with the lower appellate court to decide by framing a point of determination that these are the point of determination, the court is giving a judgment, because the trial court gives the judgment on issues, and then the appellate authority, the appellate court, lower appellate court, frames a point of determination. So this is one judgment on this point. The second judgment is CP Francis versus CP Joseph, 2025, latest judgment, SCC Online, Supreme Court 1896. And in paragraph 17, while this appeal, SLP reached the Supreme Court arising out of a judgment where the provisions of Section 100 are applicable, that means the RSAs when filed are under Section 100. The court also takes the note of the proviso which I had laid an emphasis on, that the court can always give a decision or a reason to be recorded in writing on any other substantial or question law not formulated by it, if it is satisfied that the case involves such question. This was a case where the court found that the question of laws, the framed by the High Court at the initial stage of admission of the appeal, required more probe and deep probe, and on deep probe it found that the reasons to, by after of course the court is enjoined upon an obligation to record the reasons that these are the question of law required, had decided the issue on the applicability of the proviso and gave the finding in favor of one of the parties. Now, the other judgment on this is the latest, is also very recent judgment, that is 2020, 18, volume 18, SCC, page 317, Iloth Valapil, Ambunidhi versus Kuna. It was a case of interpretation of a document. Now, see, it's a very important point. In interpretation of the document, like agreement to sell in cases or a suit for specific performance, in a case of a will, in a case of a gift, In a case of a note, also requires framing of a substantial question of law. Now, in certain cases, if a party places on record an original document, like an agreement to sell, or a note, or the gift deed, and other party has not admitted it. And I have come across with my experience of having sat in the North Court and the South Court. In the people have not been examining the witnesses to the document, and the court heavily relies upon those documents and gives a finding. And of course, the when matter reaches the High Court, again a question would arise whether this appeal involves framing of a substantial question of law. Of course, it would require, because the Evidence Act is also some people have an impression that the Evidence Act is only applicable to the criminal law but not the civil law. It is a wrong assumption and wrong thinking. With all humility at my command, if somebody has that opinion, I may not be saying that everybody has that opinion. But you see, the onus, a person who asserts is required to discharge the onus as per section 101 to 110 of the Evidence Act. And if he fails to do so, of course, when the matter reaches the High Court in a regular second appeal, again a substantial question of law would be required to be framed and decided by the. Now, for example, I give you a very hypothetical proposition. I say that I am a son of a particular person, and he has died, and he's left huge property, and there is nobody to succeed, and therefore I am entitled to succeed the property. Other party says no, he is not even a son. Now the onus is on that person to prove. And then section 56 of the Evidence Act says the onus is on that. But nobody relies upon that. Nobody sees the Evidence Act. And sometimes the judgments are rendered in favor of a person who asserts that he is done and ultimately succeeds on. So it's sometimes a luck or ill luck of a party, or sometimes a non-assistance to the court with regard to the provisions of the act, which results into a judgment which may not be actually sustainable in law in either of at any stage of the hierarchy of the litigation. Now, there's another judgment on this. Surat Singh versus Shri Bhagwan and others. 2018, volume 4, SCC, page 562. It is also on a point of section 100 subsection 4 and 100 section 5. Subsection 4 of section 100 says that the other party will come and say, no, 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 no. My lord, there's no question of involvement. It's just in an attempt to rehear and reappreciate the evidence. The substantial question of law has been framed by the appellant. It doesn't require, but then it's a discretion of the court to examine on the either at the threshold or at a final hearing or at whatever the stage is. So I now probably this talk would have helped many on the question on the point of the substantial question of law. Now I'll come to the other topic, that is the irregularity and jurisdictional error while entertaining the revisional petition. Jurisdictional error. Now, jurisdictional error is a very interesting expression and a phrase. In a cases where an order is passed by a civil court on any application like Order 7 to 11, seeking rejection of the claim, production of documents under Order 11 to 14, or amendment of the pleadings like written statement or plaint under Order 6 Rule 17, or on an application rejection of the interrogatories moved by one of the parties, or on production of or on non-compliance of the certain provisions, or on the return of the plaint, an order is passed, then the question comes whether it is a jurisdictional error or it is with the perversity. See, the court which passes a judgment knowing fully well that it has the power to decide, then it will also fall within a jurisdictional error in case that application is rejected in the manner as I have submitted. Earlier, against the interim orders of the civil courts, there was a remedy of filing a revision petition in the High Court under section 115 of the Code of Civil Procedure. Now, the legislature, the framers of the statute, the legislation, caused an amendment in 1999 and omitted section 150. Now, I would share my experience also on this point. We, I was most of my practice was on the civil side, so filing many revisions against the interim orders passed by the various district courts in Punjab and Haryana, and my practice was thriving on that. So one of the judges had confronted me that look here now, henceforth onwards, we are saved off the hassle of entertaining the reviewing petitions. Our hands are off. We cannot try because section 115 of the Code of Civil Procedure has been omitted, and therefore you are remediless. So there was a very fluid situation at that point, and ultimately the matter reached the Supreme Court in a very landmark judgment, which is still holding the field, which is called Surya Devi Rai versus Ramchandra Rai and others, 2003, volume 6, SCC, page 675. Now, it was a case where, along with the suit, a person had filed an application under Order 39, Rule 1 and 2, seeking an injunction ex parte and, of course, injunction after contest by the other side of restraint or a prohibitory, whatever the nature was, and it was rejected, and it is appealable under Order 43 Rule, Sub Rule 2 or 3 of the Code of Civil Procedure, and it was also upheld by the lower appellate court, and the matter reached the Supreme Court under Article 226. By that time, the provisions of Section 115 of the Code of Civil Procedure was already omitted. The High Court said the 226 would not lie because the other party is a private party and it would not fall within the ambit of Article 12, and therefore it doesn't have the power. Dismissed it. The matter reached the Supreme Court. So this is the landmark judgment where the court says that this power of the superintendent, which is prescribed under Article 227 of the Constitution of India, would come into play even if Section 115 of the Code of Civil Procedure has been omitted. Meaning thereby, if there is a jurisdictional error in the order passed by the civil court, the trial court, rejecting the applications, like the one I have already discussed and touched upon and deliberated upon, the party would not be remediless. It would have a chance to assail it. And since then, most of the time you are now practicing, all the revision petitions are being filed under 227, and any of the parties agreed can go to also Supreme Court under 137 also, 136 of the Code of Civil Procedure. So this is the landmark judgment. With the amendment came in the, it was not 1999, it came in 1st of July 2022. And then this judgment is of 1st of July 2002, and the judgment came in 2003, rescuing many affected parties who were aggrieved of the interim orders and they were remediless. See, in a civil court, if the party is proceeding with the matter and some fact arises later on, or on the basis of the pleadings of the other side, a necessity arises to move an application even for additional evidence and even at the appellate stage for additional evidence. But that right cannot be curtailed in the manner as the legislature thought of omitting 115 to cut down the litigation. The Supreme Court says no. Even if the legislature has omitted the provisions, the party cannot remain remediless. So while exercising power of 227, the High Court has a wide power to see whether the order of the civil court is suffering from a jurisdictional illegality, perversity, and if it is so, it has the power to set aside and direct the court either to pass a fresh order or allow the application filed by one of the parties. So that was the major point on which this judgment had been had brought a succor to many agreed litigants and of course the lawyers who were practicing on the civil side. Mr. Vikas, I think I have discussed all the points. Does it require any more elaboration and discussion on these points? Can you point it out to me if I missed out?
In fact, you have covered everything. The only difference would be that some people still have doubt that in certain cases still the remedy of 115 would prevail, or you can only apply the under 227 of the article of
It's always
Constitution of
safer.
India.
It's always a safer side to file under 227 because still a party can be using entangled on the maintainability of a revision petition under Section 115. Many people try to attempt to file it, but then they are encountered by the other side and sometimes other. Then he has a remedy to move an application to get it converted because it is tried by a single bench in every high court. It is the nomenclature is changed. Some people call it OP revision. In the Kerala, it used to be called an original petition. Here in this high court, we call it civil revision petition. So anybody has any question, I can help out them answering those.
Those who are watching on the YouTube, they can also post it on the YouTube chat. We will take the questions.
Okay.
Meanwhile, as we had requested Tushan, that if you could just summarize this entire session in Hindi, because a lot of speakers we have, not speakers, we have audience who wants to understand these nuances in Hindi. Or Punjabi, whatever you suits you. Punjabi would be a limited audience.
Hindi Punjabi mix chalega?
It will be mixed.
देखो भाइयों, अब तो मैं सबको भाइयों बोलूंगा because you are all my colleagues. I am on the part of the fraternity, part and parcel of the fraternity which I had come from. It was a sabbatical of 11 years and therefore I am again come back to the same side. ਗੱਲ ਇਹ ਹੈ ਕਿ ਜਿਹੜੀ ਰੈਗੂਲਰ ਸੈਕੰਡ ਅਪੀਲ ਹੈ, ਜਿਹਨੂੰ ਆਪਾਂ ਸੈਕੰਡ ਅਪੀਲ ਕਹਿੰਦੇ ਆ, ਜਿਹੜੀ दो कोर्टों के फैसलों के बाद फाइल होती है, एक बड़ा इंपॉर्टेंट पॉइंट है जो इसमें पंजाब कोर्ट में, जो पंजाब हाई कोर्ट है, उसमें तो सेक्शन 100 सीपीसी लगता नहीं क्योंकि उसमें ऑलरेडी अमेंडमेंट हो चुकी। हमारे हाई कोर्ट में पंजाब कोर्ट्स एक्ट लगता है और उसमें ऑलरेडी सुप्रीम कोर्ट ने कह दिया है कि इस हाई कोर्ट में तो पंजाब कोर्ट एक्ट लगेगा। पंजाब कोर्ट एक्ट 1901 का बहुत पुराना एक्ट है और सेक्शन 4 कहता है कि आप रेगुलर सेकंड अपील उसमें फाइल कर सकते हैं और उसमें ये जो सब्सटेंशियल क्वेश्चन ऑफ लॉ है जो सेक्शन 100 का सीपीसी का है, ये एप्लीकेबल नहीं होगा। तो पंजाब हरियाणा हाई कोर्ट की बात करें तो इसके पास बहुत वाइड पावर है टू डिसाइड दी आरएसए हर एक पॉइंट पे, इवन ऑन रीअप्रिशिएशन ऑफ एविडेंस इन केस इट हैज नॉट बीन, अगर वो नहीं पढ़ी गई प्रॉपरली। और बाकी जो दूसरी स्टेट्स हैं जहाँ पे ऐसा लोकल एक्ट नहीं है, जहाँ पे ये आरएसए लोकल एक्ट जैसे हमारे पंजाब में फाइल होती है, तो वहाँ सारी रेगुलर सेकंड अपील्स सेक्शन 100 ऑफ सीपीसी के अंदर फाइल होती है और जब भी अपील फाइल करनी होती है, जिसने भी ड्राफ्ट करनी होती है, उसको अपने हिसाब से अपने दिमाग से पढ़ के सारी एविडेंस, एक तो मेरी सबको सलाह ये होगी जब भी आपने रेगुलर सेकंड अपील बनानी है, जब आपके पास पेपर बुक आती है तो नॉर्मली एक्सपीरियंस मैंने जो देखा है कि उसमें कागज कई बार पूरे नहीं होते। अब कागज क्या होने चाहिए मेरे हिसाब से? प्लीडिंग्स, दावा, जवाब दावा और उसका जवाब, उसके बाद इश्यूज, वो तो चलो जजमेंट में लिखे होते हैं, फिर जो दावेदार है उसके डॉक्यूमेंट्स, जो जवाबदार है उसके डॉक्यूमेंट्स, फिर जो जिसने जवाब फाइल जिसने दावा फाइल किया उसको हम प्लेंटिव बोलते हैं, उसकी गवाही, उसका क्रॉस एग्जामिनेशन, और जो डिफेंडेंट है उसकी गवाही और उसका क्रॉस एग्जामिनेशन। ये कंप्लीट सेट होना चाहिए क्योंकि यही सेट फिर अल्टीमेटली जो भी वकील ऊपर निचली कोर्ट में डिस्ट्रिक्ट जज की कोर्ट में जाता है, सिविल कोर्ट में डिस्ट्रिक्ट जज बोला जाता है और क्रिमिनल कोर्ट में उसको सेशन जज बोला जाता है, तो वो वहां पे उसको पढ़ के दोबारा उससे बहस करते हैं और उसके बाद वही के मैटर दोबारा हाई कोर्ट में आता है। जिसको चैलेंज करना हो, या पंजाब कोर्ट सेट के अंदर करना हो या सेक्शन 100 के अंदर करना हो। अब क्या होता है, अगर लोगों ने अपील नीचे, माइंड ना करना, मैं तो बोलता हूँ कई बार नीचे की अपील ही को कॉपी किया जाता है और कई बार नहीं पढ़ा जाता, और कई बार मेहनत में थोड़ी सी प्रॉब्लम आ जाती है। तो मेरी सलाह ये रहेगी सारे छोटे भाइयों के लिए, जो भी आरएसए में जिनके पास जैसा काम आता है और आरएसए फाइल करते हैं, सारा दावा पढ़ा जाए, सारा जवाब पढ़ा जाए, गवाहियां पढ़ी जाए, डॉक्यूमेंट पढ़े जाए, अपना दिमाग लड़ाया जाए, फिर जजमेंट पढ़ी जाए। फिर आपको ऐसे पता चलेगा कि जज ने कहाँ गलती करी है। और जब आपको ऐसा पता चलेगा, फिर आप आरएसए ऐसे बनाएंगे सब्सटेंशियल क्वेश्चन ऑफ लॉ में, जैसे कि आप कोर्ट में बहस कर रहे हैं। और फिर अगर आपकी वो ग्राउंड्स ऑफ अपील ऐसे बन गई, तो जब भी केस की बारी आएगी आपने इसको पढ़ना है, और आपको केस सारा याद आ जाएगा, बिल्कुल टिप्स पे आ जाएगा, आपको पता होगा कौन सा डॉक्यूमेंट कहाँ है, और आप ऐसे ऐसे करके बहस करेंगे। अदरवाइज क्या होगा, जब आपको जज क्वेश्चन पूछेगा, आपको प्रॉब्लम आएगी कि वो आपको पता नहीं, वो अपने पेज नहीं पढ़ा हुआ, क्रॉस एग्जामिनेशन का वो डॉक्यूमेंट नहीं पढ़ा हुआ, उसका गवाह कौन था, वो गवाह एग्जामिन हुआ था कि नहीं हुआ था, उसने क्रॉस एग्जामिनेशन क्या बोला था। तो ये सारी चीजें बहुत जरूरी हैं। अगर आपको ये कोर्ट क्वेश्चन पूछती है और उसका आप जवाब नहीं देंगे, तो अल्टीमेटली क्या होगा, या तो कोर्ट अडजर्न करेगा, आपको बोलेगा दोबारा पढ़ो, क्योंकि आफ्टर ऑल कोर्ट ने तो फैसला पार्टी को देना है ना। या फिर जब आपको 4 मौके मिल गए, 2 मौके मिल गए या 3 मौके मिल गए और उसके बाद भी आपने नहीं किया, तो कोर्ट को अपना दिमाग लड़ा के फैसला करना पड़ेगा। उससे फिर नुकसान किसका होता है, पार्टी का नुकसान। मेरी गुजारिश सबसे ये रहेगी कि हमेशा इंडिपेंडेंट पढ़ के जाइए। और कुछ मैंने देखा है, जब वकीलों के पास केस आता है हाई कोर्ट के लेवल पे, ये डॉक्यूमेंट्स मिसिंग होते हैं। तो पहला भी जब आप एंगेज होते हो, तो पहले आप सारा पेपर बुक देखो, सारा लफाफा देखो, और उस लफाफे में देखो कि ये कागज नहीं है। तो अगर क्लाइंट आता है तो क्लाइंट को लिख के दो कि मुझे ये कागज चाहिए। अगर वकील साहब साथ में आते हैं तो उनको बोलो मुझे चाहिए। और वो टाइम लग जाता है, अगर उसमें टाइम जा रहा है तो आप लिमिटेशन में एक इनकम्प्लीट अपील फाइल करके लिमिटेशन बचा सकते हैं, रोक सकते हैं। उसके बाद आपके पास 30 दिन और 40 दिन होते हैं कि आप रीफाइल करें, उतनी देर में वो डॉक्यूमेंट आ रहा है उसको ड्राफ्ट भी फाइल करें। सो दैट आपको ये दिक्कत, जब आप आरएसए जब लगती है बहस के लिए, तो आपको सब्सटेंशियल क्वेश्चन ऑफ लॉ जो फ्रेम करना है अपनी तरफ से, वो भी बनेगा बड़ा अच्छा। और कोर्ट को भी बड़ी अच्छी सेटिस्फेक्शन होगी कि हाँ वकील साहब ने मेहनत करी है और ये बनता है, और फिर आफ्टर ऑल आपको स्टे भी मिलेगा और आपको नोटिस भी होगा। तो मेरी गुजारिश ये है, अगर आप दूसरी साइड से पेश हो रहे हैं और आपने उसी वही प्रोसीजर अप्लाई होगा, आपको सारे डॉक्यूमेंट पढ़ के जाना है जब भी बहस होनी है। तो आप बोलेंगे भाई साहब इसने तो देखो, जज साहब इसने तो, जो वकील साहब ने अपील बनाई है इसमें तो स्पेशल क्वेश्चन ऑफ लॉ नहीं है, ये देखो ये डॉक्यूमेंट ये है, ये तो दोबारा आपको बोल रहा है दोबारा पढ़ो। ये तो आप पढ़ ही नहीं सकते। इस सिर्फ क्वेश्चन ऑफ लॉ भी होती है जहाँ पे ये क्वेश्चन ऑफ लॉ सेक्शन अंडर लगता है, जहाँ पे हमारे हाईकोर्ट में नहीं लगता, वहां पे भी फिर लिमिटेड पावर रह जाती है कि यार ये तो ये दोबारा भी बोल रहा है, ये तो सारा कुछ ठीक लिखा हुआ है। तो ये दोनों वकीलों के, दोनों तरफ के वकीलों को ये रूल अप्लाई होता है, एक वकील के रूल अप्लाई होता है। और बहस करते करते जज को भी पता चल सकता है कि यार जो इस वकील साहब ने बोला है ये क्वेश्चन ऑफ लॉ मेरे हिसाब से नहीं बनता, और दूसरे वकील साहब ने जो ऑब्जेक्शन नहीं की नहीं बनता, वो भी गलत है। तो मेरे हिसाब से एक और क्वेश्चन ऑफ लॉ बनता है जो मैं फ्रेम कर सकता हूँ, उसको एक प्रोवाइजो दिया गया है सेक्शन 100 सेक्शन 100 सब सेक्शन 5 के अंदर। उसके अंदर अभी जो ये लेटेस्ट जजमेंट आई थी, जो मैंने 2025 की बोली गई थी, उसमें जज साहब ने, सुप्रीम कोर्ट ने वही पावर एक्सरसाइज करके उसको फैसला करा और उसको रिमांड करा कि भाई इस पॉइंट पे आए। अगर अगर वो सारी डिस्कशन हुई थी तो वो कोर्ट खुद भी फैसला कर सकता है। तो ये तो रहेगी रेगुलर सेकंड अपील की बात। अब आ गई जुरिस्डिक्शनल लेवल में। जैसे नीचे नीचे कोर्ट में केस चलते हैं, तो कुछ ना कुछ सिचुएशन ऐसी आ जाती है कि जिसमें आपको कई बार आपका दावा या जवाब दावे की अमेंडमेंट करानी पड़ जाती है। कई बार जब आप देखते हैं यार ये दावा तो मेंटेनेबल ही नहीं है, ये तो लगता ही नहीं है, या ये तो मेंटेनेबल ही नहीं है अंडर एक पर्टिकुलर प्रोविजंस ऑफ द एक्ट के अंदर, तो एक पावर होती है सीपीसी में ऑर्डर 711 की, तो बंदा एप्लीकेशन फाइल कर देता है रिजेक्ट करने की। जब एप्लीकेशन रिजेक्ट हो जाती है, तो पहले हमारे पास संविधान के साथ, हमारे कोड ऑफ सिविल प्रोसीजर के हिसाब से एक प्रोविजन था 115, सेक्शन 115 ऑफ सीपीसी, जो 1/7/2002 से अमेंड हो गया और ओमिट हो गया। तो उससे पहले जो भी ऑर्डर पास होते थे, रिवीजन पिटीशंस एक फॉर्मेट में हिसाब से फाइल होती थी, और उसमें एंटरटेन होती थी मेरिट पे, जो भी फैसला होना है इधर गया उधर। अब वो जब सेक्शन ओमिट हो गया, ऐसे ऑर्डर फिर भी पास होने शुरू हो गए। और लोग क्या करें, जो लिटिगेंट अफेक्टेड है उनका हाथ तो कट गया अगर सेक्शन 115 निकल गया। तो उसके बाद ये मैटर एक ऐसा आया, बड़ा लैंडमार्क जजमेंट है जो मैंने आपको सूर्य देवी बोली बोली है। उसमें एक केस में लोगों ने एक दावेदार ने बीच में जो दावा डाला था उसके साथ एक स्टे मांगी। स्टे रिजेक्ट होगी, फिर ऊपर अपील डाली नीचे डिस्ट्रिक्ट जज की, वो भी रिजेक्ट होगी। अब उसके बाद 115 तो हट गया। तो अब उन्होंने क्या किया, उन्होंने आर्टिकल 226 के अंदर रिट फाइल कर दी। अब आर्टिकल जो 226 है वो कहता है कि रिट लाई अगेंस्ट द स्टेट। अब स्टेट की आर्टिकल 12 के अंदर डेफिनेशन है कि कौन कौन सी चीजें हैं, पब्लिक अंडरटेकिंग्स हैं, बॉडीज हैं, जिसमें सरकार का डीप बीच में काफी ज्यादा रोल है, वही सिर्फ उन्हीं के खिलाफ रिट फाइल कर सकते हैं और किसी के खिलाफ रिट नहीं फाइल कर सकते। तो हाईकोर्ट ने वो डिसमिस कर दी। तो अल्टीमेटली वो सुप्रीम कोर्ट चली गई। जब वो सुप्रीम कोर्ट चली गई तो सुप्रीम कोर्ट ने कहा नहीं, ठीक है, ये बात कि लेजिस्लेचर ने ये रिमूव कर दिया सेक्शन 115, बट जो अफेक्टेड लिटिगेंट है, चाहे वो प्लेंटिफ है जो दावेदार है या जवाबदार है, वो रेमेडीलेस नहीं हो सकता, उसके हाथ नहीं कट सकते। तो एक हमारे संविधान में लिखा हुआ आर्टिकल 227, जिसको जो पावर सिर्फ हाई कोर्ट के पास है, सुप्रीम कोर्ट के पास नहीं है, सिर्फ हाई कोर्ट के पास है। और वो उसको कहते हैं पावर ऑफ सुप्रिटेंडेंस। मींस हाई कोर्ट को एक सुप्रिटेंडेंट पावर है देखने के लिए नीचे कि भाई ट्रायल कोर्ट सारे काम ठीक कर रहे हैं कि नहीं कर रहे, सारे फैसले ठीक कर रहे हैं कि नहीं कर रहे, सिर्फ वर्किंग में नहीं, फैसले भी ठीक कर रहे हैं कि नहीं कर रहे, ऑर्डर भी पास कर रहे हैं कि नहीं, ठीक नहीं कर रहे। तो उसके तहत उस सूर्य देवी में ये लिखा गया कि जैसे भी ऐसे ऑर्डर होते हैं, अगर 115 ओमिट हो गया तो पार्टी रेमेडीलेस नहीं है, वो रिवीजन पिटीशन 227 के अंदर डाल सकती है, चाहे वो जुरिस्डिक्शनल एरर है, चाहे वो इलीगैलिटी है, चाहे वो परवर्सिटी है। तो वो कोर्ट देखेगी कि भाई ये इस दायरे के अंदर वो केस आता है या नहीं आता, तो फैसला हो सकता है। तो पार्टी के राइट्स नहीं टेक अवे होते। ये आज का कानून है जो आज खड़ा है अभी। आई थिंक ब्रदर आई एम क्लियर अबाउट दिस।
Yeah. Yes. Now, one question is posted. It is intermingled what I have received in the WhatsApp. It says, how do courts differentiate between question of law and substantial question of law?
See, it is
Is there any
always
difference? Or,
no substantial. You see, no, let's go to section 100. It is mentioned substantial question of law. Let's go to section 100. It's a very pertinent question, and I must appreciate the person has raised this question. See, section 100 starts with second appeal. It says, save as otherwise expressly provided in the body of this court or by other law for the timing in force, an appeal shall lie to the High Court from every decree. एक तो पहले सबको ये बताना जरूरी है कि कई बारी लोगों के पास सिर्फ जजमेंट आ जाती है और लास्ट में डिग्री का कई बारी मिस हो जाता है या कई बारी फट जाता है और हट जाता है। तो जो अपील है वो जजमेंट के खिलाफ नहीं लाई करती, अपील हमेशा डिक्री के खिलाफ करती जो एंड में लगी होती है, जिसकी एग्जीक्यूशन फाइल होती है जब एक बारी फाइनलिटी आ जाए उस जजमेंट को। पास्ड इन अपील बाय एनी कोर्ट सबऑर्डिनेट टू द हाई कोर्ट, सबऑर्डिनेट टू हाई कोर्ट में ट्रायल कोर्ट भी आ गया और डिस्ट्रिक्ट जज भी आ गया। इफ द हाई कोर्ट इज सेटिस्फाइड द केस इन्वॉल्व्स ए सब्सटेंशियल क्वेश्चन ऑफ लॉ। क्वेश्चन ऑफ लॉ देखो हम क्या करते हैं, जो हमारी रिट क्वेश्चन बनती है तो उसमें हम तो क्वेश्चन ऑफ लॉ आते हैं जी कि कॉन्स्टिट्यूशन की ये धारा के अंदर हम वायलेशन हो गई तो ये क्वेश्चन ऑफ लॉ है। अब आपने इसको एलेबोरेट करके इसका फैसला करना और हम आपकी हेल्प करेंगे बहस करने में। अब जो सब्सटेंशियल क्वेश्चन, शुड आई कंटिन्यू इन हिंदी और इंग्लिश ब्रदर विकास?
it can be English because that will be a larger canvas.
Okay. So substantial
This
means.
question will be taken in English.
Sorry?
Question will be taken up in English. The question and answers.
Okay.
Because that's for the larger public.
Okay. So the substantial question of law means that it is not like the, you would say, once the court has examined thoroughly the entire evidence, the entire documents, and thrashed out everything, including the argument of one side and other side, and gives a judgment. And similar is the finding by the lower appellate court on the similar point, affirming the view of the trial court. Now, it is called a concurrent finding of fact and concurrent finding of fact and law because the last court of the appellate court is the last court of fact and law. Then when the RSA comes, that is regular second appeal, then simple question of law because we are dealing with a factual aspect. In a writ court, we frame a question of law. In a regular second appeal, it is on a substantial question only, that there is some important question of law that is substantial, there is some substance in it. And until unless substance means connected to legal point, like misappreciation, misdirection, non-reference to the statutory provisions of the CPC, Evidence Act, some other related act like Transfer of Property Act, like Special Relief Act, various other acts which may be touching upon the decision of the suit or not. And then the non-reference to the settled law, then it is a substantial question.
Like what you told about the decree, the one question is there, sir, if Order 7 Rule 11 is rejected by the trial court, giving cogent reasons, can the High Court in Section 115 allow the Order 7 Rule 11 by giving separate reasons, thereby allowing the Section 115 and setting aside the order of the trial court?
The Section 115 has been omitted to the limited extent. Yes, High Court can set aside. High Court can allow the application and reject the plaint. It can. But mind you, one more thing. The trial court also entertain and allow the application under Order 711. High Court comes later. Then that order is not revisable. It will not fall within the jurisdictional error or illegality and perversity. It will be termed as a decree as defined under Section 2 of the CPC. Now, please read with me Section 2 of the CPC.
Who read with Order 43?
Huh?
For the purposes of Order Section 2 read with Order 43 for the purposes of
in Order 43, it is not provided. Read with now, of course. Now, what is decree? Subsection 2 of Section 2. A decree means a formal expression of an adjudication, which, so far as regards the court expressing it conclusively, determines the rights of the parties with regard to all or any of the matters in the controversy in the suit, and may be either preliminary or final. It shall deem to include a rejection of the plea and determination of any question within Section 144, but shall not include adjudication from which an appeal lies, an appeal from any order or render or dismiss in default. So many times when I was sitting as a judge here, against the orders allowing the application under Order 711, people used to come in revision petition. And sometimes, in many cases, notice of motion had been also issued because this point was never touched upon, and sometimes one is not. Some judges are not provided assistance because they have not been thoroughly gone through the provision. And some, if who have practice on that side, may have a knowledge. With all humility, at my command and respect. So whenever it is confronted to a particular judge, then it is pointed out that no revision lies against it, only an appeal lies, means before the appellate court, before the lower appellate court. And against that, you can come in appeal, again an appeal, which is called a second appeal against the order SCO. Any other question, brother?
Yes, one question we have already did. Next is, how you define a jurisdictional error? Because sometimes a common man also feels jurisdictional error could be territorial, pecuniary, or there are other jurisdictional error also for the purposes of deciding the revision or for filing of the revision.
See, a revisional jurisdictional error requires a threshold breach. The subordinate court either stepped beyond the legal limits of its power or failed to exercise the power within it. This is the jurisdictional error.
So, thank you, sir. And we believe on behalf of Beyond Law CLC that we will keep on having more sessions and people will be illuminated by the knowledge which you have shared today. They say that आगाज अच्छा है तो अंजाम तो अच्छा ही होगा, चलते रहेंगे.
और भी किसी टॉपिक पे मैं जरूर I would like to again associate and enlighten my brother lawyers on other topics so that this knowledge has to be shared. It can't be, you see, gulped and kept inside. It has to be shared. And ultimately, it is helpful to all, and it is basically a rendering to the society. Thank you very much for
The law,
joining me
but
on this
the law,
webinar and giving an opportunity to share my views.
Yeah, I'm saying in the law they say that first learn, then remove the L, it automatically becomes earn.
You know, I just share a little bit if you have some time. Whenever initially at the initial stage of my practice, whenever the matter used to come, you must have also done the same thing. I always used to first search a law on that point and then draft my petition. It helped me in evolving what is the point involved in that. And if you inculcate this habit, it gets ingrained into you, and then of course sky is the limit.
Yes. Another thing, if I remember when you were a lawyer, we used to discuss that first is undergo the BRAC, then try to understand what can be caught up. Like this Order 7, Rule 11. A lot of people don't understand these nuances. As a lawyer, you will understand that what is a decree and when revision would lie. So it emanates from Order 7, Rule 11 itself.
Yes.
So I'm just giving that this is one of the classic examples of Order 7, Rule 11, the subtle difference when it becomes a decree and when it is divisible and when it is appealable.
And similarly, when somebody moves an application under Order 7, Rule 10, like territorial jurisdiction, suppose I give you, if you have 5 minutes, everyone has a 5 minutes. I would like to enlighten my brother and colleagues. See, it's a very interesting question. There are two types of jurisdictions, territorial jurisdiction provided under the Act. One is Section 16 and one is Section 20 of the Code of Civil Procedure. Section 16 is with regard to the immovable property. Then, of course, the suit has to be filed where the property is situated. Whereas Section 20 says a part of cause of action where residing or where the defendant resides. I give you a very hypothetical proposition. Now, a company is situated in Ludhiana. Its corporate office is in Delhi. Both the parties have an address in residential address and working place in Ludhiana and as well as in Delhi. Now, a dispute arises between the director and ultimately, some parties file a civil suit or some party goes to the CLB. CLBs, of course, goes Delhi, and ultimately then the jurisdiction against that order comes to the competent High Court, that is Company Appeal, where the registered office of the company is situated. Now, during those proceedings, if one of the parties or majority shareholders come across that the other shareholders, other directors have committed a fraud, or manipulated the documents and created certain documents, then they have two options. It's a very important thing. They can file a suit for recovery for damages and amount in Delhi and as well as in Ludhiana. It is not only in Ludhiana. So in such situations, many lawyers, of course, with the experience, they would like to encash on this situation and utilize the provisions as provided under the CPC. Move an application Order 710A, sir, you don't have the jurisdiction, please return the plaint and tell them to file at Ludhiana, not at Delhi. So against that order, appeal lies, because if the application is allowed, appeal lies. If the application is rejected, then revision lies. Same proposition.
Yeah, the basic understanding is when it becomes decree or when it doesn't become a decree. Basically, judgment and decree and judgment itself.
Yes.
Thank you, sir, for sharing your knowledge.
Thank you, Prakash.
Everyone stay safe and enjoy the match today.
Enjoy the match and wish India all the best and good luck. Thank you.
Same here.